It's a pleasure for me to introduce our next panelist, Professor Stephen Easton. Steve is the former dean and current William T. Schwartz Professor of Law at the University of Wyoming, where he teaches professional responsibility, evidence, and trial practice. A long time ago, he also served as the United States Attorney for the District of North Dakota. Unlike most legal academics, Steve continues to try cases. He has tried dozens of cases to verdict and handled numerous workers' compensation hearings. He has tried cases in all 4 chairs available to U.S. trial lawyers, as a prosecutor, as a defense attorney in criminal cases, and as both plaintiff's counsel and defense counsel in civil cases. The American Bar Association will be publishing the 2nd edition of his book, Opposing the Adverse Expert, a comprehensive guide for every stage of litigation, early in 2018. Steve is one of the leading litigation experts in the country and will be sharing some of his insights about how pain neuroimaging may play out in the courtroom. Professor Easton.
All right, thanks, Tavi. I want to start with a couple of usual lawyers' caveats. That's the way we sort of always start things out. I don't have any financial disclosures that are involved in the presentation today, but that sort of relates to the caveats that I have never personally had a case where the issue of pain neuroimaging evidence and its admissibility has ever been raised. I do have, I think, a fair bit of familiarity with how litigation actually works, and so I hope I can bring that expertise. So I'm sort of an ambassador from the world of litigation, and to a certain extent, my comments today will be not only from that world, but from the future of that world, sort of imagining if this technology continues to develop to the point where it might provide information about whether or not a particular person is suffering pain, or at least indicating nociception, which I hope I've said that correctly, or something close to that. How might that affect litigation in a common law system that we have in the United States, Canada, and other jurisdictions whose systems derive from the British system. So a few comments about that system, and I hope that you will take these in the don't shoot the messenger. I'm not necessarily saying this is the way the world should be, although I will have to admit that I am a big believer in our system of justice. But there's a few aspects to our system of justice that I think we need to remind ourselves when we think about new technology. First, we have a combative system of justice. One side presents its evidence subject to the other side objecting and potentially keeping that evidence out. And then the other side presents its evidence subject to the other side objecting. And then we battle out in front of a jury or other fact finder. So if this is a workers' comp hearing we're talking about, it would be an administrative law judge. If it's some other form, Social Security, disability compensation, it would be an administrative law judge. But we expect the fact finder to resolve the disputes between the evidence that has been admitted in the case. We do not in our system, expect the fact finder to go out and collect the evidence in the role of a fact finder. Now, there are systems like that. In fact, that is probably the majority system. There are probably more people in the world today that live under that system, sometimes known as the continental system, the French system, the Spanish system, and it is probably a more common system than our system, where the judge actually has the responsibility of going out and collecting the information. That is not our system. And I think that's an important thing to keep in mind as we think about how this type of evidence may develop. Another aspect of our litigation system, particularly in cases that involve pain, which are going to be compensation cases or tort cases, is that it is almost exclusively a zero-sum game. One party wants to obtain from the other party a payment of some sort. And the party that has the purse does not want to make that payment, and that's just those are realities of our system that we have to keep in mind as we're thinking about this type of evidence. And then the last sort of general point I'd raise is one that Tavi introduced very well in his comments on the panel, which is that there's a lot of money at stake in pain. Pain is a big dollar aspect of compensation systems, in the administrative law system, and certainly in the tort system. Among lawyers who do work on personal injury cases, the non-pain aspects of the damages that a plaintiff can recover are usually not significantly in dispute. I mean, what were the person's medical bills as a result of this automobile accident? There's occasionally a dispute about whether or not the person overtreated, but really quite infrequently. That's a pretty well accepted number. What were the person's lost wages, and what will the person's lost wages be in the future? A little bit more dispute on those types of issues, but not much. And those sort of hard damages, those relatively indisputable damages, are what lawyers sometimes refer to as special damages. So the real action in a case about what the verdict will be in a tort case, and to a more limited extent what the compensation will be in an administrative law context, is how much can you convince this fact finder, that is the jury, that the plaintiff is suffering pain and is likely to suffer pain in the future. We call that category of damages in our system pain and suffering. And we specifically tell jurors, you are to determine how much pain and suffering this person has already endured as a result of the negligence or other misconduct of the defendant, and how much do you expect the person to endure in the future. I said that was my last, but I have another thing that we have to think about that's particularly important on in this context, is that our system gives the litigants, and here, of course, we'd be primarily concerned about the plaintiff, who has or has not suffered pain and the extent of that pain, one shot. At a particular moment in time, the system will decide what has been the pain, the compensable pain, and what will be the pain in the future. And we don't go back and revisit that. That person has one shot. And so at that moment in time, when that decision is made, we as a system have to deal with whatever the state of science is at that moment in time. And it is the nature of science that it gets better as it goes into the future. That's my understanding. I'm not a scientist, but that's my understanding of scientific endeavor, is that you who are scientists learn more and more, and so we get smarter and smarter as time goes on. But for this plaintiff, we have to make a decision, and for the defendant who is trying to reduce the amount being paid, to those two litigants, we have to make a decision at this moment in time as to what evidence is going to be admissible. And the fact that it's going to get better in the future does not necessarily mean that the evidence is not admissible at this moment in time. So, Todd, if we go to the next slide, which is the Rule 702 slide, this is the basic federal rule of evidence provision, which outlines the admissibility of expert testimony. And the kind of evidence we're talking about would be brought to the jury through the offices of an expert witness, someone who gets on the stand and explains whatever aspect of pain neuroimaging is available at a particular point in time. So if we just go through this rule a little bit at a time, the green language sort of identifies that expert testimony is presented by someone who has specialized knowledge. And that is reflected in the orange language in subparagraph A. The first qualifier for expert testimony is that this person knows something that we do not expect the ordinary fact finder to know. We do expect the ordinary fact, including members of jurors, to have a certain amount of knowledge about how the world works, a certain amount of understanding, common sense, a certain amount of experience that they've developed collectively in the case of a jury or individually in the case of an administrative law judge before the trial. We supplement that, if you will, lay knowledge with expert testimony when the expert knows something we wouldn't expect. We wouldn't expect the fact finder, the ordinary fact finder, the non-expert to know. That's the fundamental purpose of expert testimony. And if we're going to have a system that relies on lay people like jurors to make these decisions, we really need to help them out by providing this additional information. Now, the history of the use of experts, and as Tavi's introduction pointed out, it's my thing. I mean, the thing that I study is the use of expert witnesses in trials. And the vast majority of expert witnesses that are called in American trials and administrative law judge proceedings are called as what is referred to as evaluative experts. They take their expertise and they apply it to the individual's facts and circumstances that are present in this case. And you will see that reflected in the rest of this rule. Subsection B, I've highlighted in blue facts. The expert has to be applying the theory to some facts. Subsection C is that the theory is reliable. We'll spend more time talking about that in just a moment when we get to the next slide. And subsection C is that the expert has reliably applied the specialized knowledge to the facts. That's essentially what expert witnesses do. They take specialized knowledge and they apply it to a set of facts. And as has customarily happened in American trials, they reach a conclusion. In the context we are talking about, that conclusion might be something like, this plaintiff is, in fact, suffering pain, or this plaintiff is not suffering pain. And then, of course, even if they are suffering pain, then you might get expert testimony about to what extent are they suffering pain. How do we quantify that pain? That's what we've traditionally used expert witnesses for. In Amanda Pustelnick's comments, and I would highly recommend to anyone interested in this issue, her law review article at 66 Alabama Law Review 1099, 66 Alabama Law Review 1099, an article that Amanda published in 2015. She notes a potential use even today. So for a moment, I'm not the ghost of Christmas future. For the moment, I'm the ghost of Christmas present. But I'm stealing completely from Amanda on this. So I owe all this analysis to Amanda. But she points out that even though, in her opinion, we are not yet at the point where pain neuroimaging can tell us enough about whether a particular individual is suffering pain for it to be admissible, in her view, there is still a role even today for pain neuroimaging testimony to explain to the jurors that pain is real, and that pain in the absence of something that shows up in an x-ray, pain in the absence of a bruise, pain in the absence of a broken arm or a broken arm that is now healed, but there still may be pain, that pain neuroimaging may overcome the reluctance of American fact finders, jurors, and administrative law judges to believe that there can be pain in the absence of those sort of physical markers that jurors and judges can see. I think it's a really important point because jurors trust their eyes, and judges too, but especially jurors trust their eyes more than their other senses. And if they can't see something, they find it difficult to believe that it exists. And so there is a role even today for something that we are not using enough in the current justice system, which is the teaching only expert. The expert who says, this is how the world is. And I can't tell you exactly whether this particular person is suffering pain, but what I can tell you is people do suffer pain, and I can show it to you. Not for this person, but I can show you the general phenomenon of what pain looks like through the studies that have been done. And I'm not prepared and I'm not capable to tell you whether or not this person is suffering pain, but that could be very powerful evidence for claimants and for plaintiffs to overcome this idea that, and it's a very powerful idea, that if we can't see it, it doesn't exist. And by the way, there is a relatively recent precedent for that. And the situation I'm talking about is where, remember I said that, and the rule says we bring experts in when jurors don't know something that is important because the experts have specialized knowledge. Well, what if the jurors and all of us think we do know it, but we're wrong? So what if we have this view that there has to be some objective, seeable, I don't know if seeable is a word, but visually observable a phenomenon for there to be pain, but we are wrong about that. And that's where you could bring in these teaching-only experts even today to correct that if, as I understand it to be, and I'm not an expert in science, that is what the science is telling us at this point. And the relatively recent predecessor of that I think is starting to be accepted is memory experts. Elizabeth Loftus and her predecessors that have shown how many ways we can end up with an incorrect memory, and that was essentially. And when people were first presenting that type of evidence, they were running into the roadblock of judges saying, "We don't need expert testimony to tell jurors about how the memory works because we're all human beings. We all have a memory. We all know how it works." And for a while, there had to be a fight to say, "Yeah, we know, but we're wrong." And so we need to bring in this expertise. It seems to me that if my understanding of the current state of this knowledge is correct, that there's a similar role for teaching experts. And there will be resistance. There will be resistance, first of all, because the teaching expert, although perfectly allowed under the rules, is not very common. We tend to use evaluative experts. And then the second resistance will be, well, pain. Everybody, the party resisting that evidence would usually be the defendant. In the circumstances we're talking about, would say we don't need that. The fact finder doesn't need that because everybody knows how pain works. All right, so if we concentrate for a moment on C in this slide, the testimony of the expert has to be the product of reliable principles and methods. That gets us to the next slide, which is what I'm guessing is familiar to most of you that would be watching this, which is the basic Daubert criteria. And so I won't spend a lot of time on this. I'll stop in a couple of moments. I mean, the first thing that the Supreme Court lists, and maybe I should back up and say, in the United States Supreme Court's decision in Daubert, they did not provide an absolute checklist saying, in order for expert testimony to be considered reliable, it must do this, and it must do this, and it must do this, or you must establish this. That's not the way they work. They did the sort of bundle of factors thing that the United States Supreme Court often does to us as lawyers and say, here's a bunch of things to consider, and then the judge will make the decision about whether or not the testimony is admissible. So none of these under the Daubert regime are absolutely sacrosanct. You absolutely have to have it or you can't get the evidence admitted. But it's the United States Supreme Court saying these 4, or depending on how you count them, 5 factors are important. That's going to have some influence, and it's had a lot of influence in the now just about a quarter of a century since the Daubert decision. By the way, some people say Daubert and some people say Daubert. The family actually pronounced their name Daubert, and we usually name cases after families, so I say Daubert, although I realize that I'm saying it wrong. The correct pronunciation should probably be Daubert. All right, so what did the Supreme Court list first? Testing. That makes sense if we're talking about scientific validity. I mean, that's how you, the scientists, determine the validity of something. You test it, develop a theory, and test it. So it makes sense that's near the top of the list. Peer review, which is closely related to testing, both because you probably have to have some decent testing, and because you're subjecting yourself to the disprovability. I'm not sure that I'm saying that right, but once you put something out and publish it, you're subjecting yourself to someone potentially proving that you are wrong, and that's another. So it's pretty closely related to testing. And the error rate and standards, I'm going to pause on that one for a moment, because the Supreme Court says it has to have an acceptable error rate. Now, it doesn't have to have zero error rate. There are few, if any, testing mechanisms that have a 0% error rate. The Supreme Court doesn't tell us what it has to be acceptable, but it says it has to be an acceptable. That's one factor a court should consider in determining whether or not this type of evidence, any type of evidence based upon specialized knowledge, is admissible. And so that gives lawyers like me the chance to fight, right? I mean, is 76% accuracy, is that good enough? What are we going to require? 82% accuracy? And it's important to recognize that those decisions are going to be made by individual judges when they are confronted with evidence offered by a party who brings the evidence with a belief that the evidence will help them achieve the result they are trying to achieve in the zero-sum game of litigation. That's how it works. And at first, those will be individual decisions by individual judges, and they will not be consistent. There will be a judge somewhere in Maine who says, good enough, we're going to let this expert testify. And a week later, there'll be a judge in New Mexico who says, no. And that's the way advancing science enters the courtroom, especially in a post-Daubert world. Now, at some point, if the science continues to develop, and if it gets especially general acceptance, which is the last factor on this list, used to be the only factor, and still is in the Frye states, but now is just one of the factors. At some point, courts will say, will not require this individual battle if this science continues to develop strongly enough. And an analogy I draw to there would be radar. Shortly after World War II, that's my understanding of the history. Other people can check it out because I'm not sure I have it right, but that's how the story's been told to me. People discovered you could use radar, not just for military applications, but you could start to measure the speed of objects, moving through the universe relative to the ground. And hey, here's a use for it. Let's see if we can measure the speed of cars. Well, the first time some prosecutor tried to prosecute someone for a speeding violation based upon radar, that prosecutor had to prove up the science to the satisfaction of that judge. And some of them probably lost in those early days. And those battles and individual cases continued to be fought until we got to the point somewhere along the line. And if we feel strongly enough about this, or if we feel good enough about the science, generally under a general acceptance idea, there comes a point where we say, okay, we got it. Radar can assist us in determining the speed of a car. Now, you're still going to have to prove that it was correctly used in this case, that the machine was correctly calibrated, that the officer who was using it knew what he was doing, but we no longer require in every speed-based radar case to prove the science of radar. So if we want to go way into the future, there may be a point, maybe, if this science continues to develop, where it's not going to be disputed that pain neuroimaging is, to use Amanda's term, a painometer. My understanding is we're a long ways from that, and we may never get there. And so in between, you're going to have individual litigants who think it's in their interest to bring forth this evidence. The other side may oppose it, and if so, the judge is going to have a decision to make under these criteria and under 702 to determine whether or not it's going to be admissible, and it's not going to be consistent. And those outside the justice system will find that very frustrating and say, well, why don't you folks just decide whether it's admissible or not? But if the science continues to advance, it's going to be a long time till we get to that decision. And instead, it's going to be individual-based decisions. All right, if we could have the 401 slide. This is the standard for relevant evidence under the federal rules of evidence. And I should probably mention that the federal rules of evidence are not controlling in state courts, but they're very influential, as federal provisions tend to be. And so our standard for relevance is very low. We do not require certainty. We do not require anything anywhere near certainty. The only standard for relevance is that this piece of evidence has a tendency to make a fact more or less probable than it would be without the evidence. That's a very low standard. Our system, again, the combative system of justice that we have, sort of has a default for accepting evidence, not for rejecting evidence. And it's a very low standard. Now, there are other things to consider, like whether or not there's unfair prejudice, whether or not the evidence confuses the jury. That's under Rule 403. But the standard for relevance is very low. And therefore, my understanding is that nobody thinks you can really measure pain. You may be able to measure nociception, which is related to pain, and I'm undoubtedly saying the word wrong, but you might be able to relate. We might get to the point where we can measure nociception, but pain is, as the definition in the consensus report of pain, is an unpleasant sensory and emotional experience associated with actual or potential tissue damage. I don't know that we're ever going to get to the point where we can measure that, but we may be able to suggest whether there are or are not markers of nociception, which I understand to be the neural process of encoding noxious stimuli, which is related to pain. But under our very low standards of relevance, that at some point will probably be close enough. The fact that we can't measure pain but can only measure something related to pain is not that unusual. We introduce circumstantial evidence to suggest to a fact finder that they should draw an inference from something that we can measure, and ask them to draw an inference from that all the time. So I don't think that's ultimately going to be something that keeps this evidence out. But again, it's not really, I'm not really in a position to say whether we are at the point where this evidence meets the test. If we're talking about evidence specifically to say, we have done this type of neuroimaging, and we are either going to say we think it supports the plaintiff's claims of pain, or that we think that it is inconsistent with those claims. It's a really interesting issue. If one of you some days wants to retain me to fight that issue out, I think there's really interesting arguments on either side of that issue. But I'm not in a position to say whether we are there or not. I just want to say it doesn't take as much for it to be admissible in a litigated proceeding as it probably takes for it to become the accepted science within your scientific communities. And you may find that shocking, but it goes back to the fact that we have to make this decision at this point in time based upon the science that we have available at this moment in time. And so the idea that this is a vast overstatement, but that the perfect is the enemy of the good doesn't really work in litigation. Now, if I'm fighting this evidence, I'm going to tell the judge, no, you shouldn't let the jury have it because there's all these problems associated with it. But it doesn't have to be perfect. It doesn't have to be anywhere close to perfect. Arguably, it doesn't even have to be all that great, because it only has to make a fact. This evidence has to make the fact somewhat more or less likely. And then if we go to the final slide, this is not an aspect of trials itself, but related to trials, and that is the independent medical examination. So the federal rules of civil procedure and the rules of pretty much every state that I'm aware of allows, if someone's mental or physical condition is an issue in the case, and that would be true of pain if there's a dispute about the extent of pain, allows the opposing party to go to the court and force that person to undergo an examination by the expert of the opposing party's choice. So one issue that will eventually happen if we get to the point where we do think that pain neuroimaging may give us indicators about whether someone is or is not experiencing pain and the extent to which they're experiencing pain is, can a defendant in that case force the plaintiff to undergo whatever is the technology that the expert would be relying upon? Can you force someone into an fMRI machine? If that's, and I apologize for not knowing exactly what the stage of technology is, but can you force that? There is a procedure for that. I mean, a legal procedure for that called the independent medical examination. And that leads me to the last, well, I shouldn't say last, I already said last in the introduction. I always tell my students, don't say it's last, so maybe it's not the last, but I'm nearing the finish line. With all litigation phenomenon, you have to remember what Deep Throat said in Watergate: follow the money. And if we're talking about the practical realities of when this stuff is going to start showing up in courtrooms in significant measure, you got to ask yourself, who can afford this? And well, at this point in the science, it may benefit a plaintiff to be able to call someone to say, yeah, you can have pain without visible indicators of pain that we traditionally think of, and I'll show it to you on this machine, which will give you some visual image. It is difficult for me to believe, as someone who has, as Tavi pointed out, been on both sides of litigation, both on behalf of plaintiffs and on behalf of defendants. It's usually the defendants who are going to finance the advances in what you might call litigation affecting technology, right? I mean, an individual plaintiff at this point would have to have a huge amount of pain and suffering for that individual plaintiff to be able to finance this science right now. It seems to me, and I don't know the details, but it seems to me. And by the way, the reality of that is it's not going to be the individual plaintiff, because the individual plaintiff is not working. The individual plaintiff is very often destitute and has a horrible life circumstance. It's going to be a plaintiff's attorney, a plaintiff's law firm, that's going to have to finance that science in an individual case, hoping that they will recover because the plaintiff will recover those damages. It sure seems to me that in what I might call the near-term future, it's going to be the defendants that are going to, the insurance companies, the non-insured huge entities, self-insured huge entities that are going to have the financial stake in pushing this technology, if they think it's going to benefit them, if they think they're going to be able to recover the costs of providing the jurors with this information through reduced awards. That's, again, a prediction from the ghost of Christmas future. I don't know that I'm going to be right about that, but boy, it's really tough for me to see until this technology advances a long way and it becomes relatively inexpensive for an individual plaintiff or claimant. And I am under the impression that that's a long way off. I could be wrong about that, but that's probably a long way off. And so we're going to have the usual imbalance. And this doesn't mean this is bad science. I don't mean to say that. But it's usually the defendants who are able to finance the advances in science that can affect litigation outcomes, just because of reality. And again, I'll wrap up where I started. Please don't shoot the messenger on that. I'm not saying that's the way the world should be. I mean, these days I almost always represent plaintiffs when I'm involved in civil litigation, and I've come to become very frustrated with the financial realities of litigation. But I do think it's something, if we're going to think about what's going to happen, that we have to think about. It's fascinating. I have no idea. It's very dangerous to come and say, this is what I think is going to happen, because what the heck? Somebody might look 20 years from now and see if I was right. But for what it's worth, those are my thoughts about how this really fascinating interaction between psychiatry, litigation, and the issue of giving jurors something and other fact finders that they can see is going to work out in the next few years. Thanks much.